Well, let's get more now on the government's appeal against a High Court ruling last month that it must seek approval from Parliament before starting the formal process of leaving the EU.
Well, the Attorney General, that's Jeremy Wright, told the Supreme Court this morning that the issue goes to the very heart of the British Constitution.
Well, Michael Dougan is an expert in constitutional law at the University of Liverpool and joins us now from there via Skype. Good to talk to you. This is all this morning we've been hearing about prerogative powers. Just explain what that means in layman's terms.
Well, basically, when we're talking about the prerogative powers of the government in this case, we're talking about a residual set of powers that the executive, the government, possesses almost as a matter of historical curiosity, really. Powers that the government possesses that have never been taken away from them simply by Parliament. The particular royal prerogative power at issue in the Miller case at the moment is the power to conduct international relations and foreign affairs as well. So that's the particular royal prerogative power. And the big debate in this case really is exactly how far that power extends, exactly whether the government can use it to trigger the Article 50 notification without further authorisation from Parliament, or whether, as Miller and the other the respondents in the case are arguing, whether in fact that's a much narrower power that can't be used to violate rights.
Now, obviously, we've got this far. We've got as far as the Supreme Court. There isn't really anywhere else to go. How tricky a legal decision is this? I mean, how will the judges make their decision?
I think it is a very tricky decision, and it's quite a finely balanced case as well. And there's quite a lot of disagreement among constitutional lawyers and other academics as well as practitioners about exactly which side of the case should prevail. I mean, I think one of the things that will probably mark this case out as different from the decision in the High Court is because we're hearing, because the case is being held by an unprecedented panel of 11 judges in the Supreme Court, it's very likely, I think, that we're going to end up with a split decision. So probably a majority judgment and then some dissenting judgments as well, which obviously then makes the case quite an interesting one to pick through, but also potentially can sort of increase the dissatisfaction perhaps for whichever side ends up losing the case. But it is a really, really tricky case. And it's been interesting this morning to see the government's approach to it, bearing in mind they lost in relatively embarrassing terms in the High Court. Their arguments were criticised really strongly there. So they have tried to re-emphasise a couple of key points of the argument, really, about the idea that this is not an interference with parliamentary sovereignty for them to possess this royal prerogative power to trigger Article 50, and also to emphasise the idea that this is just the start of a process in which Parliament's inevitably going to be involved.
If there is a split judgment, as you say, if it comes down to a majority judgment, what will happen then? Will that then give the losing side further opportunity to appeal against this appeal?
No, I think ultimately what will happen is that the case will just be decided on majority grounds. But then, of course, at least in those terms, the respondents or the appellants, the government or Miller and Dos Santos, will be able to perhaps, nurse a little bit of grievance in a sense, because one of the interesting things about this case being held by a full panel of 11 means that we are going to hear every single justice of the Supreme Court's view on this as well. And there are interesting debates about whether, if the court had been composed in a different way, maybe a panel of 7 or 9, could that have affected the result overall? I suppose the other issue as well is that it is whether there is in fact a further appeal onwards, perhaps even to the European Court of Justice. I think that looks very unlikely. There would need to be a reference from the UK Supreme Court. And I think one thing that does seem clear is that the court in the past has tried to avoid making references to the European Court of Justice in related cases where it's been dealing with very contentious domestic political issues. So I think a reference is unlikely. So it probably will be the case that you will just have a decision on majority grounds if it comes to that, and the losers will have to accept it, unfortunately for them.
And on that subject of the court wading into political arena, do you think the Supreme Court has perhaps been a little bit bolder than we might have expected?
Well, I think it's interesting that Lord Neuberger, right at the start this morning, tried to set the tone of saying this isn't about revisiting the political debates from the EU referendum. This is about questions of law. And of course, that must be right. But I think one of the interesting things about constitutional law is inevitably in deciding these finely balanced legal questions, the political context is going to be really important. So we've seen interventions from a couple of the judges already this morning talking about the implications of the referendum vote and exactly how that feeds into the legal question about whether the government has the power to trigger Article 50. That was something that the High Court didn't really pay much attention to. So, in one sense, yes, this is about points of law On the other hand, constitutional law is always something which occurs in a political context, so it will be difficult for the court to sort of tread that very careful line and really try to ensure that their legitimacy is maintained, because the courts below were subject to some very difficult attacks from the media, enemies of the people and so on, for what was perceived by some to be interfering too closely into these political questions.
What are the potential ramifications for Parliament after this decision? I mean, could it change the way that this country is governed from the future, this decision aside?
It potentially could, although I think one of the really interesting things about this case is it's such an important and major constitutional case about the division of powers between Parliament and the executive, but it's not entirely clear, actually, in terms of the substantive implications of a decision against the government, what that might amount to. I think it generally seems to be the case that Parliament will probably feel bound by the authority of the referendum result, even though legally it was advisory. In political and constitutional terms, really that result has very significant democratic authority. So it may be that we go all the way through the legal process, and if the government actually does lose in the end, Parliament may still be pushed into the position of having to rubber stamp the decision to trigger Article 50. And actually, some people may see that as a diminishing of Parliament rather than a sort of reassertion of their sovereignty as a result of the legal challenge. So there's potential concerns there, I think.
Interesting stuff. Michael Dougan, expert in constitutional law. I'm sure we will be calling upon your services again over the next few days. Thank you very much.
Thanks a lot. Thanks.